Carol Beaumont.
Very, very much, Mr Chair. I also wish to join my colleague, the Honourable Phil Goff, in acknowledging the Minister and the Chair, Chester Burrows, and in fact just reflect on the point that our Junior Whip, Ian Lees-Galloway, made, that you would make a fine Justice Minister, and in fact you may have an opportunity to be so quite soon.
That's right. There's a vacancy coming up.
Yeah, there could well be a vacancy in that area, so I wish you luck with that, Minister. But getting on to the bill, the Victims of Crime Reform Bill, and we're speaking now in part 2 of that bill. As others have said, this part is about ensuring victims' rights in the adult criminal jurisdiction are applied in the youth justice jurisdiction. And so that goes through and in part 2 reforms amends the Children, Young Persons and Their Families Act 1989 and talks about certain situations, including family group conferences, when a child or a young person is in custody pending hearings, and what happens in situations where children and young persons abscond, and talks about the fact who can be present at hearings of in situations where there is a child or young person who is the perpetrator of the crime. I just want to reflect here for a minute. When I spoke on part 1, I talked about victims of sexual violence and the particular needs of that group and the particular impacts and very deep impacts often of sexual violence crimes. And of course that would equally apply in this part, and in fact we've seen situations, quite troubling situations in this country not that long ago around young persons and sexual violence with the so-called Roast Busters case in Auckland, where very, I think, troubling cultural attitudes displayed by young persons around sexual violence. And so in that situation, in the youth jurisdiction, you may well have both youth perpetrators and youth victims potentially affected by the changes in this part. I understand that, well, you can see in part 2 that a number of changes have been made which I think strengthen the provisions here. So in terms of better victim support at youth court hearings, amendment in this part in clause 38 to bring support people without seeking prior permission, while allowing, if necessary, the judge to restrict numbers. Also in 38A, clause 38A, it means that victims of offences committed by a child or young person would be notified when the child or young person absconds from a youth justice residence. Also, as the Honourable Phil Goff mentioned, also that would apply about being notified when the child or young person dies in a youth justice residence. In terms of the definition of victim in clause 39, that definition aligns then the definition of victim in the Children, Young Persons and Their Families Act with that in the Victims' Right Act. So those are some of the provisions in part 2. I just want to pick up a point about funding though, because in the regulatory impact statement it does clearly say that agencies have indicated that to successfully implement some of the proposals they will need to look at to reprioritise funding from other areas. If funding cannot be reprioritised, then this may result in pressure on services and service delivery may be affected. Now, I'm sure that none of us would like to see service delivery for victims of crime affected, and it specifically identifies 2 of the provisions in this part as being within that category of the need to ensure there's adequate funding, and that is the automatic access of victims of child and youth offenders to the youth court, and also the proposals around victim impact statements in both the adult and youth jurisdiction. So I understand the Minister did comment on that, but I would just like to ask him if he would just really like to comment in a little more detail, given the very clear concerns that were flagged up around this issue in the regulatory impact statement. So, in concluding on part 2, I'll leave it there.
Jamie,
I move that the question be now.
I'd very much like to hear Raymond Ho.
Thank you.
Excellent decision.
Excellent decision. Thank you very much, Mr. Chair. And much has been